Hi, I'm Tom Marks with the Marks Law Firm in Orlando, Florida, and welcome to the Healthy Family Law Attorney. Today I'm going to talk about what you need to do to prepare for mediation. So the good news first, about 80% of cases settle by the time you go to mediation. And I consider mediation up until the time of mediation to be the uncontested portion of the case. It's only after mediation that you're going to start seeing the judge and having contested hearings. That's when the case is going to get more expensive. It's not that a case can't settle once it goes into the contested phase after a mediation has impassed, but the good news is about 80% of the cases settle at mediation or before mediation. So what do we need to do to prepare for mediation? I believe preparation wins the day. Okay, so what do you need to do to prepare? Well, first, you need to make sure that you get all of the document production that you're entitled to and that you should get in the case. So first of all, you have mandatory disclosure. Those are documents that each side is supposed to provide to the other side. I've done videos on all of the specifics of what goes into and what gets produced through mandatory disclosure. But you have to make sure not only do you get all the documents, that you read them, analyze them, understand exactly what they're showing, make sure that there's no hidden assets, or you got to follow those paper trails. And you may need to do a request to produce, which is just simply a larger document production going back further in time. There's also interrogatories, requests for admissions. So you get all of that discovery done up front before you go to mediation. And you make sure that you get the financial affidavit from the other side. That I've done prior videos specifically on the financial affidavit, and I've done a deep dive there. But I would say that the financial affidavit is the most important financial document in the case. If somebody lies on a financial affidavit, that's considered fraud on the court. There is no statute of limitations on that. You can always go back if you find that the other side has omitted assets or underreported assets or something of that nature, and ask the court for relief there. But for mediation, you make sure you get the financial affidavit, all of the document production, so that you have everything to prepare the documents that you need to have at mediation. The first document you need to have ready to go, if you have minor children, you are going to be required to have a parenting plan. I've done a prior video on parenting plans, so you can do a real in-depth review of that video, and it does go into quite a bit of depth. So the parenting plan, I think, is the most important parenting document in the case. It's going to talk all about how you're going to co-parent the minor children, what the time-sharing schedule is, what about extracurriculars, what about school district, what about relocation. All that kind of stuff is in the parenting plan. And if you have young children, you have to anticipate that the parenting plan is going to impact and control your life as a parent for the next 16, 17 years if you have a 1 or 2 year old. So even if you have teenagers, the parenting plan provides a lot of detail about extracurriculars and school and all that. You can put things like college plans and what about college expenses, and does somebody pay tuition or room and board or books or whatever. Legally, the obligation of support for children ends at the age of majority. So in Florida, it's age 18, but the statute does say that it can continue until age 19 if the minor child is still in high school with a reasonable expectation of graduation, but not beyond the age of 19. Let me just say this though. In the parenting plan, if you and your spouse or you and your significant other, say in a paternity case, want to agree to something that's outside the law, like child support continues beyond 18 or 19, or that college expenses will be paid, even if legally that's not an obligation, you can certainly contractually obligate yourself or agree to that in the parenting plan. Okay, so there's a lot of flexibility there, and it's another reason to avoid court, because when you get to a trial, a judge does not have that flexibility. A judge cannot do the same kinds of things that you can do in a parenting plan, in a mediation, in a settlement in the case. Okay, a couple of other things I want to say about the parenting plan. I just want you to think long-term, and I want you to think change. There are very few things people can guarantee for you in life, but one thing I can pretty much guarantee for my clients is things are going to change. The children are going to get older. They're going to go through different developmental stages. New technologies may come up. New opportunity. A pandemic we just went through. Who would have anticipated that? So think change, think long term, because you may meet somebody, there may be a new significant other on the other side. The new marriages, new significant others can change the dynamic. So I want you to think really detailed too. You want a lot of detail in the parenting plan. But in the final analysis, if you and your spouse can work really well together, like through a collaborative case or cooperatively, and agree to co-parent the children in the best interest of the children, then you can put that parenting plan in a drawer and just co-parent the children as works out best for the two of you. That's in a low conflict case. I get that, not in a high conflict case, but you would only need to then pull out the parenting plan if there was an issue or dispute in the future. Okay, one last thing about the parenting plan, you're going to have a child support guideline worksheet. If you have minor children, it's a matter of public policy. You're going to have child support calculated. I've done a prior video on how to calculate child support, so you can watch that and it'll give you all that detail. All right, let's move to the next thing you're going to need for the mediation. That is a marital settlement agreement. So the parenting plan deals with all of the children's issues. The marital settlement agreement deals with all of the financial issues. So what's going to happen with all the assets and debts? You're also going to want to put together, or your attorney should put together, an equitable distribution worksheet. I've done a prior video in detail on that. That's going to list all of the assets, all of the liabilities, and the net, how much of each of both of the spouses are going to be receiving. And if there's an imbalance, they're not approximately equal, then there's what's known as an equalizing payment. Again, I get into more detail in a prior video. So that is going to be attached to the marital settlement agreement. That's going to show the parties exactly what assets and liabilities they get. And so the marital settlement agreement is super important. It's going to have other issues in it, like alimony. Okay, if you have an alimony case. Alimony is a very complex topic. There's 6 types of alimony in Florida. I have done a prior video on that too, a very deep dive on that. I'll just say here, the number 1 and the number 2 factors in every alimony case is, 1, does the payor spouse, the one who's going to be paying the alimony, have a financial ability to pay it? And does the payee or the recipient spouse have a financial need to receive the alimony? If you don't have both of those, you don't get to all of the other factors in Chapter 61.08, age of the parties, health of the parties, length of the marriage, and all that. and then you don't get to all the types. So if you want to know more about alimony, watch that prior video. But for this purpose, you want to make sure when you're preparing for mediation, you have an alimony analyzer worksheet. It's something we put together that there is no formula that the court has to follow for alimony in Florida like there is for child support. Yes, we have a formula for child support. There's a guideline worksheet. We have software. You can figure it out to the penny. Alimony is much more subjective, a lot more factors. However, we do have some rules of thumb. We have the AAML, the American Academy of Matrimonial Lawyers. They have a formula we use as a rule of thumb. There's what we call the failed statute. It's a statute that was passed by the legislature in Florida a few years ago that the governor vetoed. An aside here, there is indication that there is going to be a change in the alimony statute this year, and that they may again attempt to put in a formula. But for right now, there's no formula that the court has to follow. But we do use those rules of thumb, and there's some others of percentages of net or gross income that we can look at. We go over with the client. Okay, so your attorney will have met with you or should meet with you to prepare you for that mediation. The last thing I'm going to talk about is attorney's fees. Attorney's fees are similar to alimony, but not as complex. There's not all the other factors. It's just simply, does one party have a financial ability to pay attorney's fees to the other party? And does that other party have a financial need to receive the attorney's fees? Don't get into age and length of the marriage and all that for attorney's fees. It's basically to try to even the playing field so that both spouses have an equal opportunity to retain counsel. All right, so your attorney will meet with you. I typically meet with my clients about a week prior to the mediation. We make sure we have all the document production before we meet with the client. We make sure we have a draft parenting plan, a draft marital settlement agreement, a draft equitable distribution worksheet, a draft child support guideline worksheet, and a draft alimony analyzer worksheet. So I go over all that with the client. I give the client oftentimes all of those documents to take home with them to look at, consider, because I consider the client part of the case. I consider the client part of the team. The client knows the facts more or better than the attorney could ever know them. Hopefully the attorney knows the law better than the client. So when you put those facts and that law together, it makes it a much stronger, more robust, better representation of the client, and the client feels more involved in the case. I've done a couple of prior videos on finding the right attorney for you. I would suggest if you're looking for an attorney, you can check those out. But your attorney should be very clear, answer any questions you have. You should make sure you have all your questions written down so you make sure you don't miss any of them. But you want to go into that mediation knowing exactly what the game plan is. I always say it's kind of like what's in the ball field, okay? What's in bounds, in the sense of what are the potential settlement parameters of what's going to happen in the sense of equitable distribution, alimony, child support, time sharing. Here's what's in the ballpark. This settlement might be a single or a double. This would be a home run. You might want to have your line in the sand already thought out before you get to mediation, so you're really well prepared. And you're not going to go further than a certain line, but you'd be happy with from here to here and so forth. So that way you don't feel so pressured at mediation, because at mediation it's going to start real slow. The mediator's going to talk to you about, here's what mediation is all about. I'll hear all the benefits of mediation, which is true. You avoid court, you avoid the expense of going to trial, you avoid a judge who doesn't really know you, just making some black and white kind of decisions in your case and not really knowing your unique situation. So that's all going to happen at the beginning, and then you're going to start getting into what's known as caucusing, where the mediator will take you into separate rooms, or the mediator will shuttle back and forth between different rooms. Right now, it's rooms that are virtual on Zoom, breakout rooms. But once we get back to in-person mediation, it'll be in the mediator's office or in the lawyer's office. And then what'll happen is, though, you'll start getting close, and then you'll start running out of time, and the pressure will build, and you want to avoid that kind of pressure. So I would say the more prepared you are, the less stress, the less pressure you will feel. Okay? That's how you prepare for mediation. That's a lot about mediation. Again, the good news is 80% of cases do settle at mediation. So our purpose, I want to provide hope and help to your family to successfully navigate the family law process in a healthy way. So I hope I've accomplished some of that today. If I have, hit that like button, subscribe, hit that bell icon. Would love to hear from you. I'm starting to receive more and more comments to the videos, so I will respond to your comments. If you have a suggestion of a new video in the future, I'd be happy to look at that and provide that content for you. So have a great week, and thanks for joining me today. Bye-bye.